I just want the witness to understand that that is where we landed. So I do not expect a response, or I don't think the commissioners would expect a response from the witness that she cannot answer because the matter is in court. That issue has been settled. The only issue that is outstanding is a self-incrimination issue, but that is the subject of the third statement that we are going into. Do you understand my position, Advocate Johnson?
I do, Counsel.
Okay. I think I'm clarified. So, is that when you referred us to the transcript, is that the only place you found where reference to sub judice?
Yes, in the time that I had, that was the one that I
Yes.
could recall. And
okay. And then, as Commissioner Khumalo points out, notwithstanding what you stated, page 61, that you are unable to expand on that as those matters are in court and sub judice, you proceeded to answer questions relating to those matters.
Correct.
Before ad hoc. So, in fact, much as you raised it, you did not seek to assert it fully and insist that the rule be respected throughout.
Correct.
Thank you. Okay. I'm indebted to my learned friend for reminding us of that. After a heavy lunch, I think. Are there any other issues that perhaps you were to consider during lunch, Advocate Johnson, that you would like to bring to the attention of the commissioners before we go to your third statement?
Commissioner Khumalo had asked that I look at the statement of O'Sullivan at paragraph 1.8.3, which I did. And I do see what he says, but I can only recall a complaint that came from the Office of the Minister as well as Adams section 27. I can't take that paragraph further than what it states in 1.8.3. Just to indicate, Commissioner, I did read it. Thank you.
Thank you. Then I think we're ready to turn to our third and final statement that appears under tab 3. As I indicated, it's dated the 20th of July, 2026, and it's a 5-page statement. You deal, the crux of the issues are from your paragraph 5, and to this end you reference the Rule 3 notice that you received following testimony by Colonel Rule Officer Captain McLean and Witness O. You do not adopt the ad paragraph approach in that statement, but we have availed a copy of the Rule 3 and the issues you were called upon to respond to, which you seek to do in this particular statement. So when you are ready, I think you can safely say you can skip paragraphs 1 to 4 as they reiterate what you already have stated in your first statement and repeated in your second. So if you could take it from paragraph 5, thank you.
Paragraph 5, statement 3. The notice requires me to deal with allegations against me, testified to by Colonel Kobus Rule Officer, Captain McLean, and Witness O. The allegations, as summarized, implicate me in alleged criminal conduct. 6, the allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so was confirmed by the NPA on 10 July 2026, as well as by the witness McLean when he testified. Now that the matter is before the NPA on the basis set out above for a decision on whether I should or not be prosecuted various consequences emerge. One of those consequences of the need for me to have my rights protected. Paragraph 8. Thus, when I testify on those matters, should I be called upon to, I will exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. 9. I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
In summary, apart from correcting the errors identified above, this affidavit records my response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. Accordingly, I place this affidavit before the Commission to preserve my constitutional rights, to avoid any unfair prejudice arising from parallel prosecutorial processes. Conclusion. Lastly, I see the need to state, paragraph 14, that prior to my then scheduled appearance on 13 July 2026, I took ill and did not appear before the Commission. I placed before the Commission a medical certificate on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from not be made public. Should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the same of subject to time-use notice and the right to legal representation, I would be willing to make myself available for such.
Thank you. Thank you, Advocate Johnson. Is there anything else you would like to add to this statement?
Chair, there was a bundle that came last night, and what I saw in the bundle was there was WhatsApps of Barry Bateman, and there was, I think, an affidavit of Brigadier Petle. I know my counsel struggled to open it, so we were not able to consult on those matters, and I do not want to be seen to be leaving them out because they do relate to the same matter. So if where I'm talking only about 3 people, I open myself up to questions from others who all relate to the same matter. And if I could just take a minute to, if I could confer with my counsel through you, Commissioner, just to see if they were able to get to that bundle, because the first part, Advocate Sello says bundle, and then it has those names. I don't want to miss a name that might be there.
May I suggest this perhaps might assist you? You recall during the course of consultation, file 1 of the exhibit bundle was shared with yourselves.
The mic, please.
File 1 of the exhibit bundle was shared with you. This is about 10 days ago to 2 weeks ago. Do you recall that? And in that bundle 1, at Annexure 368, CJC 368. So those documents in their entirety were shared with you. And I'm trying to understand which bundle you received last night regarding the sharing of the docket with General Khan.
This is a very similar. We also got one last night at 1912.
It could very well be updated documents or additional documents to the exhibit, the main exhibit bundle, which by now runs into 7 files.
Yes.
But I'm interested in this particular bundle 1 and say you received that bundle 1 in its entirety about 10 days ago. If you look at exhibit bundles from page 1.
Sorry. Is this something you'll be dealing with? Oh, by the way, you still want to get an idea of what it is, so you may not be able to answer my question. But perhaps in fairness to Advocate Johnson, she has to confer with her counsel. Mr. Bodlani, do you want us to stand down for maybe 5 minutes, give or take, or do you want to walk across and?
Thanks, Chair. It might not be necessary. As I understand it, Ms. Johnson's issue is there are documents that we received yesterday evening.
Yes.
In respect of which we didn't have an opportunity to consult with her. I don't know if my colleagues for the Commission intended to ask her questions on those documents, but this morning we were subsequently given those documents physically. We couldn't access them in electronic format. I am able to point out now that we've got the physical bundle. From what page to what page have we not been able to talk to Ms. Johnson about?
Yes.
Now, if I point those documents to my colleagues, they might be able to tell you that they don't intend to traverse them this afternoon at least. Then that way the issue is resolved.
Perhaps let's just go out and we'll come back when it's indicated to us that we should.
If I may, before we do so, and that is the clarification I, to some extent, was seeking and was highlighting to Advocate Johnson. The bundle grows literally on a daily basis, so that there were documents provided to the team and to the witness yesterday is possible, but those would be in file 8. The issues that Advocate Johnson addresses in her third statement are the start of the exhibit file, which is from page 1, and that was provided to her 10 days ago. I just mentioned that in the context of the request she has made to confer with her counsel, just to make sure which documents we are talking about.
Can we just have that quick stand down? You'll indicate when you're ready, Mr.
Certainly,
President.
Chair. Thank you.
Yes.
Thank you.
Let's adjourn.
Find your dream car, find your happy place with Auto Trader.
Yes, Mr. Bodlani.
Thank you, Chair. Thank you, Commissioners. We appreciate the time that was given to us. It's really much appreciated. We've had a conversation with Ms. Johnson. She has pointed to us some of the documents that she didn't have, we didn't have. She has also pointed to us documents that she had, but had forgotten to bring them to our attention when we prepared the statement that was filed yesterday. But she, being under oath, she'll be able to take the commission through what those documents are, because there's a particular paragraph where they should have been inserted or added together with the others that are already referred to there. That's the paragraph that has the statements of offense and other people in the statement that came in yesterday.
Thank you then, Mr. Bodlani.
Thank you, Chair, and thank you to Mr. Bodlani. We were about to deal with the witness's third statement, and it's in that context that this issue arose. So perhaps if the witness can clarify whether the concern she expressed before dealing with her third statement has been addressed. If not, where the shortcoming is. I don't think I'm clear where this lands us. I would appreciate a clarification on that. Thank you.
Sorry, Council, I hope I understood. We are dealing with Statement 3.
Yes, ma'am. Okay. And the issue of documents arose in the context of dealing with Statement 3, you were then given an opportunity to confer with your counsel as you had requested.
May I suggest, because I did not understand Mr. Bodlani to say that anything is still outstanding, in the sense that we cannot go ahead and start with the third statement.
Nothing is outstanding, Chair.
Yeah,
the only issue I was placing on record
is
that there are documents.
Yeah, no, I followed that. I got that.
Thank you.
Got that. I think let's just go.
Then we are ready to deal with your third statement.
Please, thank you.
Okay. If then you had started on your third statement at paragraph 5.
That is correct.
And you may take it from there.
The notice
should be at your paragraph 6 now.
Yes. So I wanted to then indicate, Chair, that having consulted then with counsel, I wanted to make an addition under paragraph 5. Just for me to mention what it is, and then Commissioner will indicate if that is in order.
All right, so please go ahead.
Paragraph 5 reads as it does. It says, the notice requires me to deal with the allegations against me testified to by Colonel Kobus Rule Officer, Captain McLean, and Witness O. The allegations as summarized implicate me in alleged criminal conduct. What I wanted to add, Commissioners, is I omitted in this paragraph to deal with CJC 368 from pages 1 to 133, all included.
Page
1
yes.
Up to and including 133. That is the insertion I wish to make.
All right. Are you able, off the top of your head, I know we can find it, but off the top of your head, can you just tell us what CJC 368 is?
In Witness Bundle 1, CJC, we have 3681.
Just a description of the nature of the document.
3681 statement and annexure. Yes. Sorry.
Apologies. Okay. This is the index to the exhibit bundle, and it's from item 1. That's your CJC 368 to item 5.
That is
These are the
correct.
documents you reference.
Let's leave it. Let's continue. Mr.
Yes. She was still making an addition.
Or are
to
you
paragraph 5.
continuing with the correction or
That was the correction,
that
or
it
at least
ends-
the addition I wanted to make.
it ends-
Commissioners, to paragraph 5.
Okay.
Okay.
All right.
Then that will then take us to your paragraph 6, and you can take it from there. Thank you.
Thank you. The allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. This was so confirmed by the NPA on the 10th of July 2026, as well as by the witness McLean when he testified. Now that the matter is before the NPA...
Advocate Johnson,
Sir?
this NPA confirmation, is it in writing, and to whom was that confirmed?
Mr. Maga?
You can always come back to it. Let's just not forget it, yeah.
Yes, we won't forget it.
We
were supposed to get that confirmation for you from Advocate Bell. Thank you. Thank you, Commissioner Baloy. Now that the matter is before the NP on the basis set out above for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need for me to have my rights protected. Thus, when I testify on those matters, should I be called upon to, I will exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. Paragraph 9, I hold a view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. For these reasons, this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above, formally before the Commission. Then we skip paragraphs 10, 10.1, 10.2, and 11, and we go to paragraph 12, Commissioners. In summary, apart from correcting the errors identified above, this affidavit records my response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. 13, I accordingly place this affidavit before the Commission to preserve my constitutional rights, to avoid any further prejudice arising from parallel prosecutorial processes. In conclusion, paragraph 14,
Best Med Medical Scheme recommends that you skip this video if you're not interested in value for money medical aid with a personal touch. Get personally your service with Best Med Medical Scheme, 2025 BHF Titanium Award winner for service excellence.
on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from be not be made public. And lastly, should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the usual subject to time's notice and the right to legal representation, Commissioners, I would be willing to make myself available for such.
Thank you. That brings us to the conclusion of your third statement. And once again, to check if there are any additions you'd like to make to that statement.
It was the addition that I made,
That you made at paragraph
under
5.
paragraph 5.
Okay. you say you omitted to, in paragraph 5, you add that you omitted to deal with Exhibit CJC 368. That's the first document in the exhibit file or pack of documents from pages 1 to 133.
That is correct.
Now, I had indicated that after you have addressed your third statement, I will indicate to the Commission where my understanding is your legal representatives, Mr. Bodlani and his team, and I landed on the question of self-incrimination. And I want to test whether the rights you assert at paragraphs 8 and 9 accord with our understanding and our decision. Firstly, our understanding is you are not invoking a blanket ban on dealing with the issues that are reflected in CJC 368, the documents that you say you omitted to deal with. And that you invoke your right against self-incrimination in response to specific questions, not that questions can't be put to you. That is what Advocate Bodlani and I understood to be the correct legal position. I want to understand whether that is your understanding as well. That questions may be put to you, and in response to each question, you then get to decide whether you invoke your right against self-incrimination.
That is correct, because I understood that is the rules under which the Commission does operate, and so there is no blanket, but it is on a question by question.
Okay. Now, because it's you sitting here, you do invoke Section 3, Sub 4 of the Commissions Act. You reference it there, paragraph 8, and that is, I think, in our Act, what secures your right against self-incrimination. I find it interesting that you have a similar provision in the Act, in the NPA Act, and I want to see whether you draw a distinction between your testifying before the Commission and what those whom you engage during course of investigation are expected to do. In this regard, I would like to refer you to Section 28, Sub 8, A and B. And it will be projected soon if you don't have it immediately in front of you.
Of the NPA Act?
Of the NPA Act?
Section 28.
28, Sub 8, A and B. And Section 8A reads, I quote, "The law regarding privilege as applicable to a witness summoned to give evidence in a criminal case in a magistrate's court shall apply in relation to the questioning of a person in terms of subsection 6, provided that such a person shall not be entitled to refuse any answer, to answer any question upon the ground that the answer would tend to expose him or her to a criminal charge." Sub B, no evidence regarding any questions and answers contemplated in paragraph A shall be admissible in any criminal proceedings except in criminal proceedings where the person concerned stands trial on a charge contemplated in subsections 10, B or C, or in section 319 sub 3 of the Criminal Procedure Act. So, considering the position you assume in regard to Exhibit 368, do we land at a place where those that Idac interviews and questions are in a different position to witnesses, including yourself, appearing here today? Because if I understand sub 8, as the persons that you question during course of investigation may not refuse to answer a question upon the ground that the answer would tend to expose him or her to a criminal charge. Do you have a different standard than the one you are seeking to invoke in your protection today?
Sorry, Ms.
Yes,
Sirlo. Can you please explain to me the comparison, if it is a comparison, that you are making with this section?
The comparison I seek to make is, if I understand the witness
Let me perhaps explain.
Yes.
And I'm asking the question because this specifically relates to a witness called before a magistrate's court. Yes.
Yes. Chair, if one has regard to sub B, 8B, it says no evidence regarding any questions and answers contemplated in paragraph A shall be admissible in any criminal proceedings, except in criminal proceedings where the person concerned stands trial on a charge contemplated in 10 sub B and C. 10 B and C below provide any person who has been summoned to appear before the ID, and then A is without sufficient cause fails to appear, fails B at his appearance fails to produce a document requested, having been sworn or having made an affirmation, 1, fails to answer fully and to the best of his ability any question lawfully put to him or her. That is the comparison I seek to make, which is what the Commissions Act also provides in respect of witnesses. And my reading of sub 8 together with sub 10 would suggest that the witnesses that are interviewed, and I'm not saying interrogated, interviewed by the investigating director, cannot refuse to answer questions on the basis that they would tend to expose themselves to a criminal charge subsequently. They may not fail to answer any question put to them to the best of their ability. So I read 28 sub 8 to be equivalent to the Commissions Act section 3 sub 4, which means that the rights are the same, but it would appear that those being interviewed by the ID do not have the basis or the scope to refuse to answer questions, notwithstanding the fact that they may incriminate themselves. I just wanted to understand from the ID whether, is it the same right, or does the Commissions Act afford greater rights than the NPA Act does to those who are summoned by the investigating director to answer questions?
It's for me.
Yes.
Is it 3 sub 4 that applies, or is it section 6? Because my 3 sub 4 deals with witness fees and privilege and other things. But the equivalent of this, I see it in section 6 of the Commissions Act.
And it's because section 6 will cross-refer you to this section 3.4,
Yes.
referencing the privilege applicable to anyone, I think in a match court, if memory serves me well. So they should be read conjunctively to get to a position where a witness may invoke a right against self-incrimination. And we say that that right is protected in terms of section 3.4 read with section 6. We can get to the regulations as well. The regulations, I think regulation 8 expound further on that, but we can't rely on the regulation to interpret the act.
Can I? Can
Yes,
I add
Commissioner.
something to this, which is turning out to be a complicated issue, and without being technical about it? The provisions speak of a privilege,
Yes.
and privilege is different from the shield of self-incrimination. It's two different concepts. Privilege, as I understand it, is about your discussion with your attorney, with your lawyer. So I'm under no obligation, or our 3(4), when I say our, I mean Commissions Act, gives a witness protection not to reveal matters that are the subject of discussion with their legal representative. I didn't understand that we are in that territory with the third statement. I thought the third statement speaks to self-incrimination, which is, as we know, a completely different concept.
Yes, Commissioner, at first blush, we get where we are thanks to the Constitutional Court matter, Secretary Judicial Commission of Inquiry into Allegations of State Capture versus Zuma, 2021, bracket 5, SA1CC. That is the case that determined that the rights in Section 3, sub 4 and 6 include the right not to self-incriminate. The Constitutional Court considered, and it was argued before it by some or other amicus curiae, that it doesn't include the right of against self-incrimination, but the Constitutional Court determined that it does. They have a right not to self-incriminate. And part of the basis for that is that the Constitutional Court held in the same matter, I submit correctly so, that the rights afforded in terms of Section 35(3), sub 3 of the Constitution do not apply to a person who's not an accused person. So she can invoke Section 35 of the Constitution, but she may invoke 3, sub 4. This is what lands us here. We may not get a resolution. I raise it to make the point that the rights the witness seems to assert would appear, on my reading, to be greater than the rights afforded persons that are interviewed by the investigating directorate, and wonder whether my interpretation is correct, and should that be the case, is it not the same right? And why it is the NPA Act seems to be so stringent when it comes to the invocation of that right. I pose this question specifically to this particular witness because she happens to be a lawyer and advocate over 30 years, and they handle these matters. I take it on the regular. I thought she might be able to shed some light, but if she can't, then it would be a matter for consideration by the Commission as we go forward. If she can't give a response now, I'm happy to leave it there, Chair.
Please restate your question, perhaps, for the benefit of Advocate Johnson.
Advocate Johnson raises in the third statement the right not to self-incriminate. And we have, I think, gotten to a point where at least she and I agree that she can invoke that right in response to specific questions as we go along. Now, I consider Section 28, sub 8A and B read with sub 10, that the right she seeks to assert is not the right afforded any person interrogated by the investigating director or the directorate. And I wanted to understand if my understanding is correct or whether there is the same right. My reading of Section 28, sub 8, read with sub 5, would seem to suggest that it's not. Which would mean the witnesses that the persons that they question cannot refuse to answer on the grounds that they would expose themselves to criminal charge. And it is precisely that ground she seeks to invoke going forward in refusing to respond to questions. It need not detain us. It might be a matter that Advocate Johnson may consider overnight. I just want to know where we land on this right against self-incrimination.
Mr. Law, may I suggest that if we leave it at Advocate Johnson to consider this overnight, you may also want to have regard to Regulation 8.2, which speaks to the treatment of self-incriminating answers before the Commission. This is the regulations of the Commission. So consider that as well.
Of this commission.
Yes.
Thank you, Commissioner Baloy.
Oh, sorry, it now works.
Yes.
I was thinking that maybe it's not working because we are now where we are. No, that's fine. I think the issue I wanted to raise has since been taken care of. This matter, it being one that is going to be considered by Ms. Johnson overnight. Our concern was of what consequence really is it. Ms. Johnson is before the Commission, the rules of the Commission apply. She's not before Idac, she's not before the ID. It may very well be that the Act accords her more rights than she otherwise would have, or vice versa. But the rules of the Commission are the rules of the Commission, and that's what applies.
There comes a point when you stop chasing what's next because you finally arrived somewhere worth being. And along the way, progress starts to look different. The way you spend your time, the choices you make, the standards you set. That's the thing about a new era. It's yours. The all-new Audi Q3. Q, a new era.
The Advocate Johnson's responses will be on a question-by-question basis, and that it's not blanket.
Indeed.
Yeah.
Indeed, Chair.
Indeed, that's the agreement, Chair.
Yes, thank you.
My apologies. I confirm that, Chair. I opened that. I'd assumed, and I hope rightly so, although I think I didn't give warning, that the engagement, the probing of Advocate Johnson's testimony that she spent the greater part of the day putting before the commissioners has ended and the probing had started.
Yes,
so I start at section 28 to see if we can have an engagement that could better inform the commissioners about how these matters are dealt with. I do not for a second I'm confused about where Advocate Johnson is today. She's before the commission, it's section 3 sub 4. She heads a directorate that seems to have a similar provision in the Act, applicable Act, and I just wanted to understand how it applies to others and whether there is a difference. It's the sole purpose for which I referenced 28 sub 8. Thank you, Chair. But as we have agreed, she'll consider it overnight and we will see where we land tomorrow when we resume.
Yes. May I just start with this question? I hope it won't disrupt
Chair.
your probing. Advocate Johnson, Colonel Padiachi said that he has never been furnished with copies of affidavits that support Section 27 referrals. He testified that all that he has ever been given, as I understood it, throughout his stay at Idac, are oral briefings given to him by senior investigators or prosecutors. I'm not sure which one it is now. Let me outright say that that doesn't make sense at all to me. I say so because what needs to be investigated would be contained in the Section 27 referral affidavit. Why a senior prosecutor or investigator would hold back that referral affidavit simply escapes me. Did he tell us the truth with regard to this or not? Is that the practice followed at Idac? If it is, which I would find very strange, why would there be such a practice?
As I indicated, Chair, once I have a Section 27, or it's come from Mr. Sissoko, the necessary deliberations have been made, they go to a team. So the team would have access to the Section 27 because the prosecutors...
Would investigators at the level of Colonel Padiachi be part of that team or not?
The team has different levels of investigators and prosecutors. They have to sit and deliberate on this document and to work out what investigation would have to be instituted, what the allegations would be.
I want to understand, when you are talking about a team, who are you talking about? Would this, for example, include Colonel Padiachi?
That is correct.
The
team will have investigators. So if I take this team, it is investigators and prosecutors, both criminal and financial investigators, and he is one of the criminal investigators in that team.
And obviously, it makes practical sense as they debate issues around what needs to be investigated. It makes practical sense that the source document, which is the Section 27 referral affidavit, should be there in front of them.
In order for them to deliberate,
yes.
What are the allegations?
Yes.
Can we make out offenses?
Yes.
Is there sufficient to bring an application to the investigating director for the institution of an investigation? So I don't know why he would not have seen this one. I also heard when he testified that he said he had not had access to it. It is something I can find out, but it is not ordinary practice that no one has sight of every document. Of course, it depends on how they are working. Someone might see something, someone not, but I do not believe that there is a deliberate withholding of the documents within a team, from a team.
Would there be any reason? Colonel Padiachi mentioned the name several times of this person above him, this senior.
Chief Perumal?
I think, yes. He mentioned that name a good few times. Would there be a reason why Mr. Perumal would hold back that document?
Not at all. And from what I do recall, when the document was handed, it was handed over to one of the prosecutors so that they can go to the team. The prosecutors are the ones who usually will do the legal drafting, but that document does get shared. I did ask Chief Perumal after this testimony,
yes. and hearsay evidence is admissible here. What did he say?
He did say that he did not withhold any document. That
meaning,
Section 27,
let's be specific.
He did not
meaning
withhold the Section 27 because after the deliberations happened, the 27 was kept by the prosecutor or the project manager, but there was a 27 that was in the team.
Team including, as you said.
So what I did do, Chair, because I did become confused about the issue, I then asked what other matters is Mr. Padiachi vested in? The one, so other than these crime intelligence matters, he is invested in a different investigation. That matter does not have a Section 27 because it is a matter that emanates from the State Capture Commission recommendations. Mm-hmm. So that one will not have a 27.
Yeah, that's understandable.
Yeah, this is the one that had a 27.
Yes. All right, that makes perfect sense. I said so to him. If you say you were listening, you must have heard me. I said to him, I find it hard to believe that he would not have been furnished with a source document for it all. It just didn't make sense to me.
I understand.
Thank you.
Can I just understand this explanation? There's a difference, and that was the basis of engagement with Colonel Padiachi was him being provided, as the investigator, lead investigator, him being provided with a copy of the Section 27 referral, vis-a-vis how he explains. He says, we were briefed, we were told that there is this. Are you saying that Chief Investigator Perumal said to you that Colonel Padiachi was provided with a copy of the Section 27 referral? Is it as clear as that?
No, he said, Chief Perumal said, I didn't have the Section 27.
He said, I've never seen it. It's never provided.
It was with the prosecutor and with the project manager, because that's how they coordinate their meetings. I cannot explain why it wouldn't have been shared in that space, because that is where they have to sit, commissioners, and deliberate. All documents do get shared with the team members, because how do you do your taskings and activities when people do not have sight of documents?
I'm not sure what you're saying. Chief Investigator Perumal said to you, did he say to you that the lead investigator was provided with a copy of the Section 27 referral?
He said to me he didn't have the Section 27 referral.
Okay.
Because that is what was testified to, that Chief Perumal had it, and it was not given to me.
Okay.
Chief Perumal says, I did not have that document. That document was with the prosecutor.
Okay.
And we don't know if the prosecutor, in turn, shared it.
I see.
With Mr. Padiachi.
That clarifies it. Thank you.
So what does this mean exactly? I guess no clar, dear Mekar. Does this mean even Mr. Perumal never had sight of that document? What exactly does this mean?
I'd have to clarify. I asked if he had the document. He didn't have the document. I'm sure he should have had sight of the document.
You see the difficulty.
I'm giving a report.
Yeah, the difficulty with that is that he might have been referring to a specific point in time, and that he did not have the document at that point. I'm not sure that answers the question. Had he ever had it in his possession at any point whatsoever? Did you get to that point or not in your discussion?
Not in my discussion, but I will revert with that answer because I do believe it is important.
Yeah, let me tell you what my difficulty is with it. So the prosecutor has it. Mr. Perumal, does not have it and has never had it. And then he, according to Mr. Padiachi, gives an oral briefing to Mr. Padiachi. So Mr. Padiachi then goes ahead and investigates. He has not seen the source document. Mr. Perumal gives this oral briefing. He has not seen the source document. That's just very, very strange to me. And yet something very serious, which is an investigation, is going to commence. And yet the two people involved right at the tail end, before the investigation actually starts, have not seen the source document. I find it very difficult to comprehend any of this. Do you wish to comment on that?
I'd rather give you a clear answer after engagement. I don't want to give you an answer because I wasn't in that space at the time of their deliberations.
But that was the substance of my engagement with Mr. Padiachi, and seeing that you asked some questions, well, maybe I should not blame you, but your engagement does not seem to have covered the essence or the substance of the issue I was covering with Colonel Padiachi.
Advocate Johnson, from a different angle, I understood from Colonel Padiachi that it is you who designates an investigator to handle a particular case. Is that correct?
That is correct.
So the starting point is the Section 27 affidavit, the referral. At that stage, the investigator does not have anything else because the investigation has not commenced. So when you designate him to start the investigation, what then do you give him?
Chair, at the time the designation happens, the team would have gone through the Section 27 document, and they would have come up with an application setting out what they see as suspected offenses, who might be implicated, and what kind of investigation, if they are able to at that stage identify, must be conducted. It's an application and sets out a summary of the facts as well that would then support the application. They, in turn, as part of the designation, they put down the names of the persons who will form part of that team to conduct the investigation and the prosecution. That is the designation I sign, together with the Section 28 authorization. So what they then have, Commissioner Khumalo, is an authorization setting out offenses and allegations, persons to be investigated, perhaps resources required, a summary of facts, and this is what they need to go and do. They then take that and they are able to then sit amongst themselves and operationalize this document in terms of what is the work that needs to be done. They get the authority to investigate based on what they have identified arising from the Section 27.
And then let me ask you this. From that stage, when you accept the application or you approve it, until the 25th of June in 2025, when you write to the DPP saying you want people to be charged, at no stage during that process do you satisfy yourself that your investigator has seen the Section 27 referral. So you now, as head of Idac, at no stage do you satisfy yourself that the person on whose affidavit you are relying to bring these charges, on whose affidavit you are relying to ask for a warrant of arrest, you now, as Advocate Johnson, at no stage do you satisfy yourself that he has seen the Section 27 referral?
I do not ask that question because it is given to the team. And I work, and Commissioner Khumalo might say to me, but incorrectly so, I work on the assumption that once all documents, approvals, and authorities are given to the team accesses it all. They share it because they have to sit, they have to do the planning, they have to work out what needs to be done. So, short of someone raising a complaint or escalating to my office that in this team, I am not getting access to documents, I will not be aware that these documents that are given are not shared.
Not even a red flag that it is not part of the docket or it is not part of the documents that are given to you for the purposes of finalizing the note to the DPP. I know they would not have brought it to your attention, but you are now the final decision maker at Idac. It doesn't raise a red flag that this document is not referred to. My investigator does not say anywhere in his affidavit that he has studied the referral or he has had sight of the referral. Is it not something that you consider at all?
What is considered for that prosecution memo is the evidence that was collected as a result of the Section 28. I have to concentrate on the evidence, the law, and I put together a prosecution memo that deals with evidence and the law, and therefore the charges and what must be enrolled.
I'm aware of
Will you be asking questions around the intake committee at some point? I don't want to get there if you will be, but in any event, I'm not getting there now.
I was headed there,
Yes,
and in light of what the witness said this morning, when she was informed of what was Colonel Padiachi's testimony before the commission.
Okay.
Before I do so, however, for 2 minutes, I hope, just to clarify two issues with the witness. The first is you keep referencing the team, and that the team would have considered the Section 27. Can you perhaps assist us? How does the team come into being? It's not a permanent team, I take it. It's a team that is constituted for purposes of investigation and maybe subsequent prosecution. Perhaps if you just clarify who constitutes the team, under what circumstances does that happen, and whether it is following a consideration by the Section 27 affidavit and authorization by the ID in terms of Section 28. I want to understand, when does the team get born, so to speak? Thank you.
So, as the structure of the office stands, there are pre-existing teams. It's just for purposes of being able to logistically run the office. So there are standing teams that fall under the leadership of a Deputy Director of Public Prosecutions. And that team will have a Chief Financial Investigator, financial investigators, criminal investigators, commissioners. Each team has a project manager. And then they also have data analysts allocated as and when. Now, they are standing teams because we have so many DDPPs. And what has happened over time is you find that certain teams work well on certain matters and you build that expertise. As an example, we would have a matter where the Transnet matters are dealt with. Almost all Transnet matters get dealt with within that team. It therefore makes it easier to allocate matters of a similar nature to that specific team when they come in. However, it may be that that team is up to taking the Adams 27, if we can call it that, but they are already overstretched with court matters and their investigations. We then look to the office to see where can we best allocate this matter. Mr. Sissoko and I will have a conversation. It also talks to the allocation of work, which team might have a little less than another team, but there's also expertise. So you look at the seniority of especially the criminal and the financial investigators and the advocates, and then you assign the matter there, and then these processes run.
Okay.
Ms. Silo, I'm made to understand that at some point you indicated that we should adjourn at 4. I don't know whether the information I'm getting is correct.
The information you're getting, Chair, it is correct. I do note is 1607, and I stand by what I indicated. But before I do so, may I just place two matters on record. This morning, we started with subpoenas issued by the Commission to Idac, and Mr. Bodlani addressed you, Commissioners, about the status of the documents requested. Just to confirm that these have started trickling in, and we will update the exhibit files by tomorrow overnight. In the meantime, just to confirm that we too in the interim have added 2 other annexed exhibits, CJC 387 and 388, and have provided Ms. Johnson and her legal team with those exhibits. And once again, your exhibit files will be updated. Thank you, Chair.
Thank you. We will adjourn and resume at 9:30 tomorrow morning. Let us adjourn.
Thank you.